So as you heard, I'm a personal injury attorney. One of my favorite things about the job, but it's also one of the most stressful and the hardest part of the job, is trial. So today I'm going to walk you through what a personal injury trial is, okay? So basically the goal of a personal injury trial is to get in front of a jury and get the jury to decide who's at fault for an accident and how much that accident is worth. So the first thing that we do is jury selection. We call it voir dire, which is a French word for speak the truth. And the reason that's important is because what we really want to do is we want to get the jury to tell us the truth about their biases and concerns about our case. So how many people here have got a jury summons and been really excited about it? Exactly. So I know when I walk into that courtroom, that panel is upset at me because they don't want to be there. They have other stuff they'd rather do. I also know that they don't trust me, right? Because I've done this enough times where I ask the question, how many people think there are too many lawyers and too many lawsuits, and everybody raises their hand. So the first thing I have to do when I select the jury, and I have 20 minutes to do it, is gain their trust. So what I do is I make a pact with them. I ask them to make a pact with me. And what that is I ask them, I say, hey, I know a lot of you have bad feelings about lawsuits and lawyers, but we've never met before. So I ask that if I'm professional, honest, and trustworthy at this trial, can you put aside all of those biases you had before and judge me and my client by what we do at this trial? Everybody makes the pact with me, and now we're in it together. So now I made a connection with the jury, and then I start to tell them all the bad stuff about my case because I'm trying to knock out all of the people that I don't think will be good for my case, okay? So that's how jury selection works, and I get five people I can knock off, and then we end up with 7, 6 and 1 alternate. The next thing is the opening statement. This is my first chance to start to tell my client's story, okay? This is where I put the roadmap in of what I'm gonna show them. And I have to do it through what the evidence is gonna show. I can't argue. Now, what's dangerous about opening statement and why opening statement is so nerve-wracking is because you can't win your case through opening statement, but you can definitely lose it. And the way you lose it is by losing the attention of the jury. If you don't give them a solid roadmap and keep them interested, they're gonna forget about everything that you said and you're gonna lose your case. So the way we start, the way that we really tell the story is through witnesses and direct examination. So that may be a plaintiff who's gonna tell the entire story, a groaner witness, which is someone who knew the plaintiff before and after the accident. They can talk about how it affected their life. Treating physicians, which is the person that's gonna that treated them, and is gonna tell the jury what the injuries are, explain the injuries to the jury, and whether they're related to this accident. Cross-examination. After I've called all of the witnesses on my case and I've done the direct examinations and I've told my client's story, I have to turn it over to the defense because they get a chance to defend their case, right? So they call their witnesses and I get to do probably the most fun thing at trial, and that's cross-examine them, right? Now, all of you have seen A Few Good Men, right? You know that scene where it says, I want the truth, and he says, you can't handle the truth. That never happens. That is nonsense. Never happens. What we're trying to accomplish at trial is we're trying to get small concessions. We're trying to get witnesses, doctors, to concede to small things that help our case or hurt their credibility. Once had a doctor on the stand who had testified in another case, and I had the transcript, and he said the complete opposite thing. You know, that was a fun cross-examination because everything he said I had a counter for that he had previously said before, so the jury hated him. Very good. And you want to avoid arguing with witnesses, and you want to avoid letting them talk too much because you want to control the narrative. And then there's closing argument, right? So after the defense has called their case and they've called all of their witnesses, I get one chance to rebut, but ultimately what happens next is I get to do closing argument. And closing argument is the sexiest part of the trial, right? It is where you get to go up there and you get to argue and be persuasive and talk to the jury and try to convince them that you are the right, and it's where you ask them for what you're ultimately looking for. And that's how much money you think the case is worth. A lot of times I'll take the jury verdict form, which is something they get at the end that they have to fill out, and I walk them through it and I tell them every amount that I want. So the things that I can recover for are medical bills, economic damages, medical bills and lost wages. Those are easy, right? I show them the medical bills, I show them the W-2, and I can say, this is what my client lost. The next thing is the harder thing, pain and suffering. How do you judge pain and suffering? Nobody knows. I don't know. No lawyer knows. We go by based on what juries historically have awarded in these cases, and then we try to smash that and make sure that we get way more than that, right? So that's how we calculate our pain and suffering. We give them a number. The number, you have to have a reason for the number. If you just tell them a blanket number, no one's going to give you that or understand that. You have to have a reason. And then the final thing that we can recover for is what we call permanent injury or permanent impairment. And that means if you have medical evidence that your client is permanently injured from this accident, I mean, they're never going to recover. They're always going to be in pain. Someone in a wheelchair that's never going to walk again. Someone who's going to always have constant back pain, you can recover for that. So that's probably the most difficult for people to understand or even believe, because we're saying someone who's maybe 25 years old is never going to be able to work again, or is never going to be able to walk again. You never know what can happen, but at the end of the day, that's what the doctors have told us. That's what we're looking for. So, trial is the most stressful part of what we do, but it is the most rewarding. It is why when I call an insurance company and I tell them what I think a case is worth, they take it seriously because they know I will take them to trial and I'll win most of the time. And when a jury, and I will tell you one of the more stressful parts of the trial is when you give up the case to the jury because it's out of your hands. And now they're deliberating. There's 7 people deciding your client's fate, and you have no idea what they're talking about in there, right? So that is the most stressful part of trial. I say a lot of prayers, and I do things to distract myself. And then when they call us in, the jury hopefully will have applied the facts to the law and come up with a verdict in favor of my clients. So that's trial as fast as I can explain it in 8 minutes. I can talk about this all day, but if you have any questions about it, ask me about them later.
Hey, Ed, a quick question. What percent of your, what percent of your cases go to trial?
I would say probably, in general, in the legal industry, about 5% of cases actually go to trial. Which is why you'll see, if I don't know, you probably don't remember this in our the first presentation I ever did, I said there's a difference between a personal injury lawyer and a personal injury trial lawyer. And that's because most people you can start a personal injury firm and never try a case in your life and settle cases for whatever the insurance company offers you, or you can be good at your job and take cases to trial, win, and then the insurance companies know this person takes cases to trial. I'm not going to mess with them, right?
Yeah. So awesome. Thanks, Ed.
No problem.